Good afternoon. I hope everyone had a very nice lunch and welcome to our session, a judicial panel on developing a trauma-informed court. My name is Kathy Cockrum. I'm the liaison for program development with Texas CASA and a member of the SCTIC. Our next speakers, we have wonderful speakers. We have retired senior judge Carol Clark from Smith County, who developed the trauma-informed court film we have featured with this Trauma Institute, All Rise for Children. Judge Katrina Griffith, Associate Judge of the Harris County Child Protection Court, serving primarily children and youth in PMC cases. Judge Rosie Alvarado, District Judge in San Antonio, Chair of the Bexar County Children's Court, and Manager of the Pearls Restorative Foster Care Court. And Judge Carlos Villalon, Associate Judge for the Child Protection Court of the Rio Grande Valley West, serving Hidalgo and Starr counties and member of the statewide collaborative of trauma-informed care. Thank you, judges, for all being here today. I know you have wonderful things to share with us. We will have some time at the end of the session for questions. Please feel free to submit them during the presentation using the Q&A feature. Now, judges, I will turn it back to you.
Good afternoon. I am Carol Clark, and I am a retired judge of the 321st District Court. It is a great pleasure to be able to share with you my experiences of a judge of a trauma-informed court. Through my association with Dr. Karen Purvis and Dr. David Cross, my team and I implemented the various parts as we learned them. Back then, we were not so lucky as to have this great training that's available, so putting it together was rather a slow process. I went on this journey because I wanted better results for kids and families, but I didn't really know what to do. My best year, I can tell you, and I retired in 2018, my best year was 2017, when 48.9% of the children were reunited with their families. In setting up a trauma-informed court, all on the team must be on the same page and have some of the same training. The judge must be the leader and set the expectations. My group had brown bag lunch trainings, day-long trainings, trips to various national, state, and national and state conferences, and read books. While the communities represented here may have different resources, all have access to the basics. The general components of a trauma-informed approach applies to all courts. Defining these components for you is something I'll do quickly. My goal here is for you to look at these cases with a mindset of trauma, unlike the conventional approach, and pass that on to members of your team. Understanding trauma is a realization that the parents and children have dysfunctional behaviors and coping skills developed from childhood physical, emotional, sexual abuse, or neglect. There can be healing from these traumas with the components of a trauma-informed approach, hopefully resulting in lasting permanency for kids. Before I go any further, I don't have much time, so I compiled a packet for you with as much information about our system as possible. It's critical to me that you review it so that it may answer some questions for you as to how to do, what to do, or even if you have questions. In the packet, you will find this detail about the component parts that will serve as a roadmap for setting up your trauma-informed court. I have included some information by Liz Watkins, who you saw yesterday, who left Smith County for Williamson County and is implementing the system there. She has listed things that can be done for free. The biggest and most impactful thing that is free, and I can recommend to you, is the phased service plans, which I will address a little bit later. There is a list of 2 books and information about the documentary All Rise for Children in the packet, which is the documentary made by TCU that shows the system in action. Have everyone in your system get the books. They are The Connected Child by Dr. Purvis and Bessel van der Kolk's book. Have everybody get those books at very little cost. They're about $10 a piece. There is a handout in the packet with the names of those books. Please pay attention to the form that says ETCF Charitable Grant Form. For my retirement, my community donated funds to pay for 1 or 2 day trainings of teams in trauma-informed practices. And if you're interested, please fill out that form and it will tell you what to do. So what are the component parts of a trauma-informed court? These components are specialized assessments to identify the trauma, identify and recommend treatment, and phase plans to implement the treatment and measure the client's success. The trauma-informed system treats the clients as individuals. I think that's something we've already heard this week. So the first question to ask before drawing up a service plan is very much attuned to what happens when you get sick. You want to know what is wrong and then what is going to be required to heal you. Without proper assessment by someone who knows what it is that they're looking for to heal, like your doctor, for example, the trauma-informed assessor will then help you as a court develop a roadmap, or again, the phase plan, to describe how you're going to get where you want to go. I think all of us have been in a situation of having to find out where we're going when we get lost. And so we don't want people to get lost, much as you've heard already today. So what is the purpose of this 3-phase plan? It is the glue that's going to hold your legal case together and give all involved guidance on how you will proceed and how they need to proceed. There are templates for these phase plans in your packet that were prepared by the prosecutor in my court, and I urge you to use them. We discovered that those conventional service plans are not helpful to our client or to our team. They are not respectful of brain science. The first 90 days of sobriety, there is no clear thinking. Most of my cases were meth, but clients come to you very many times on drugs. They're not thinking straight and they're not capable of thinking straight. That's just brain science. All of your other efforts are wasted if you don't follow the brain science. The big service plan is required by the feds, has to do with money. So it is put into the CPS computer. But the phase plans are the ones that are actually filed with the court and the ones that you hold the clients accountable for. In the conventional service plan, the clients usually select the easy task first because what do they want? They want kids and drugs. They go to psychologicals, they attend their visits, they may go to parenting class, but they don't want to go to counseling or rehab. Their attitude, and thus probably yours and the team's attitude, is us versus them. And it's difficult to measure success. Remember, these clients are used to gaming a system, whether it's parole, probation, CPS, they know how to do it. Visitation of the children and the parents is tied to the phases and services as an incentive. Phase 1 is where we address safety, usually drugs, what brought them to court. There are levels of addiction, and so they must be assessed for the proper treatment. They receive supervised visitation. Phase 2, we address the risk of all the factors in their life that are impairing good parenting. That could be parenting classes, mental health classes, continued recovery things, whatever seems to be the issue of the actual parenting, jobs, work. Phase 3, they get unsupervised visitation. Phase 3 is the monitored return. We used a follow-up in-home care provider. We heard from some of the parents this morning that they really wish they had had that all along. And we tell the clients, I think we heard lack of family support for some of them. Develop your intentional family along the way. We talk constantly about that. Those are people that can support you. You pick them, unlike your own family. In the assessments, they must be done probably to get the best results by an LPC, a psychologist, a licensed social worker, or someone else with extensive trauma training. Understanding the work of Dr. Doug Marlowe, which is in the paper attached in my handouts. He is with the National Drug Court Institute and has been doing research on drugs and treatments for years. He has a matrix which we used in determining the 4 levels of addiction. Obviously, 3 and 4 are the worst problems and the ones that you're going to focus on the most. The assessment itself contains several parts. One is a SASE. We're all familiar with that. It's a computer generated where the client answers about their addiction. The ACEs, which we talked about extensively yesterday, which helps identify the childhood trauma. And then the interview with the trained interviewer. Without proper assessment of the problem, there cannot be success. If you don't know where you're going, how are you going to know when you get there? The assessments that you're going to receive from the state-funded provider on the phone, granted, it's probably a budgetary issue, but they asked your client a few questions. They're not sufficient. They're self-answer with no corroboration, and they just don't get enough information. The big, long service plan you're used to seeing is intimidating, confusing, and not done in any particular order. Without trauma-informed treatment and healing, when the brain science is dictating it, is just basically a worthless endeavor. You're not going to get success because the client is unable to succeed. After treatment is implemented, you may find down the road you need to change the treatment. We adopted the attitude that one mistake does not throw you out of getting your kids back. And we had people on drugs very often will have issues with relapse. So bear that in mind. It's a team effort to reassess the situation, hold the client accountable, and find solutions. Ultimately, it's up to the client to implement the treatments. If they don't want to do that, and a lot of these younger clients really don't, because they like the lifestyle they're living if you're 18 years old. So find out early on in your process. That helps you get permanency for the kids, look for relatives who could be permanent, and the client is involved in that decision. Trauma treatments are very different than conventional treatments. They are research-based. Some of the ones that are included would be circle of security parenting, which we used, nurturing parenting, parenting from the inside out, EMDR, which some of you may be familiar with. It's a miracle in my opinion. Eye movement desensitization, you know what I mean, and repositioning, EMDR, brain gym, and TBRI. We built our system around TBRI because that's what Dr. Purvis taught us, but you may build yours around something different. We did incorporate circle of security in our parenting class. The EMDR and the brain gym was incorporated into the counseling. Healing a family and providing support, even after reunification with family or others, is very important. We think that that will reduce recidivism and prevent a reoccurrence. The team approach is critical, and unfortunately, I'm getting pretty close to the end of my time, if not overtime. So if we have a second, I urge you to read the paper, and I want to go to the clip of a client who graduated and just this year got her master's in counseling.
I want to let the courts know that it's very important, and I literally beg of them to incorporate TBRI and bring forth what Judge Clark does, because in return, I'm able to help hundreds, and those hundreds can help hundreds. It's a domino effect. And I know I needed those resources. I needed to go through all of that with the people there at the courts. Just because I'm a drug addict and alcoholic, I do have meaning and a purpose in this world. I think it's very important that the courts don't treat you as though you're worthless or you're just space being used up. We all go through so much in life. Some of us cover it up better than others, but we need to bring forth a relationship, a connection, and to see that we're not just an addict and an alcoholic. We're not just a parent that's not caring about their child. We're going through something. It's not like I would want to go through this. It's not like I wanted to use drugs and end up 80 pounds, not having anything going for me. Who would want that? Nobody. So it's like I needed that help. I needed that extra push, that extra resource provided, that extra tool to be able to cope with these situations. It's such a blessing being able to have that provided from Judge Clark and those invested in her court. And I just pray that other courts can have that, because we can touch so many people's lives. We can stop this. We can stop this cycle of chaos and destruction.
Thank you, Judge Clark, for all that groundbreaking work that you do. My name is Katrina Griffith, and I am the Associate Judge of the Harris County Child Protection Court. My court is focused on permanency. It's children that are in the permanent managing conservatorship of CPS. This court started back in 2014. I was appointed by Judge Olin Underwood. My administrative judge was at Judge David Farr at that time, and they pretty much just pointed me to the court and said, go get these kids out of care. We really had to start everything from scratch. Let's see if I can get this. There it goes. So we started our court from scratch. We had to try to figure out what was the best way to work with children that were in permanent managing conservatorship. At that time, Harris County had the longest length of children that were in care, from TMC all the way to exit. And our focus was going to be how we can speed up that system. We want to make sure that we focused on the children. And so everything we did from day one, my coordinator, Eno, and I, was to figure out how we can make this court work for the children and work for the parents that did remain and did not have the rights terminated. Very quickly on, we learned that the traditional things that I had been doing for almost 10 years as a lawyer and seeing the way other judges were doing it was not what was best for our court. So what we decided to do in our court was create a non-adversarial hearings, even when hearings were going to be adversarial. So instead of doing traditional questions and answers from the county attorney or the district attorney with the ad litem's, we went into round-style hearings. Round table style hearings. All statutory hearings that are required by the legislation, I ask those questions directly from the bench, so I make sure that I have all the findings on the record and that information. It also gives the opportunity for everybody to participate. We tend to ask caseworkers how the kids are doing, even when the caregivers are in the room. They're the ones that are directly interacting with the children. So any question I ask is open for anybody to answer, and we give the attorneys opportunities to follow up and just make it a freestyle, which also takes down increases some of the comfort level in the courtroom. Even hearings that we still have parents on the case and they are present, we continue with the round table style hearings and give the parents opportunities to ask questions, to answer questions on behalf of their children, and to try to build a comfort level that this isn't just about the kids, it's also about them as well, and about what we can do for the best interest of the children and when appropriate to do to get the kids back with their parents. The allowing of the open participation also brings a comfort level. You can see it from the caseworkers to the caregivers to the children. We do have children at our hearing. It's very important. It's something we started from the very beginning. They are the voices, the cases about them. And as you heard from Alex and Leroy before lunch, it's definitely important for children to have a voice in the courtroom. The way we started out, at first we started having the hearings from the very beginning, the children present from the very beginning, but then we did have a hearing where a child learned some information for the very first time, and you could see it was difficult for the child to learn that in that situation. So what we decided to do from that point forward is we have the kids in the back room, the playroom, which I'll show you in a second, and we go through all the statutory questions, and then we bring the children either into the courtroom, I will go into the playroom, meet with them, or meet with them back in the chamber, depending on what comfort level that child has. Some kids really enjoy being in that courtroom. being in front of the bench, just like everybody else, just like their attorney, just like their caseworker. And that's a very empowering for them to have that opportunity to speak at that at the hearing. We swear the children in, just like any other witnesses, so they can have that empowerment. Kids that are not comfortable in that setting, we take them to the playroom and we interview them there. But having them present during the hearing will give us an opportunity to make decisions that are going to be directly relevant to the information that they're providing us, in addition to the caregivers. So one thing we wanted to do in order to bring the kids in was to create a fun place. This is one view of our, we call it our playroom. It's also known as a jury room. Since we are a permanency court, we tend not to do jury trials. So we were able to take this space and make it into something that the kids can enjoy coming into. We have kids that want to come to court because they know they can read a book, they can watch TV for a little bit, they can get away from the other stuff that's going on in their life. And sometimes they just want to get out of school. But guess what? I can still get some information from them, even if that's their reasoning, and we can still have a conversation and they still bring important information to their case. The way the room's set up right now is for our older kids and our PAL docket. We bring in enough chairs for every child to have a seat. On a regular docket, it'll be maybe 3-4 chairs there for the caseworkers to sit, and there's more toys out for everybody to play with. But by creating a fun place for the kids to come to, it takes away some of that scariness of court. It takes away some of the security concerns as well. There are cases where kids are not having contact with their parents. We're able to bring them into the secure side door of our building, have them in this room, which will keep them out of earshot in sight of any parents or person that they're not supposed to have contact with. And so it's very important for the comfort level of the children. Now, obviously I did this presentation before JJ was no longer a Texan. So we'll have to figure out what we're going to do with that when we get back into the courthouse. The other thing that we like to do for the comfort level of the children is a philosophy that I learned when I was working with an organization called PACE, is you have to feed the body to feed the mind. We have a docket that's done at 12:30, and we bring our teenagers in. And a lot of times they're going to be missing lunch to get there. So we make sure that we either have pizza for them, Chick-fil-A is donated by CASA sometimes, sandwiches, just something to be able to feed them. So when we do go through our docket and have that conversation, they are not hungry, they are focused, and they're getting something that a lot of times they're not getting in their placements, especially the children that are in RTCs. In addition to what you see here, we also have a large snack section for the kids to choose from. We have kids that come to court and say, I like coming because I get to eat chips and drink juice, and that's not something I can do in my foster home. So we just try to bring some of those extra comforts to the children. We like to create different themes in our courtroom. And I say we, I need to point out that's my coordinator, Eno. She will keep the courtroom decorated based on what's going on. That was during the Texans playoffs and the Astros playoffs runs as well. We'll do other themes around Halloween, Thanksgiving, Christmas, just different holidays, just to kind of take down some of the tension that comes into the courtroom. Since we are a permanency court, we are very child focused, and just making it friendly as soon as you walk in, just creates an environment where we can really start getting involved in what the children need. One thing that's very important that we do in our courtroom is we like to celebrate the success of the youth. This is some pictures from our graduation celebration that we did back in 2019. We had a group of kids that not just graduated high school, but also the ones that got the GED that went through our PAL program. And we just had a really just a large party for them, introduced each child individually. We talked about what they did to get to there. We talked about what their future plans were, what colleges they were going to. We talked about if they were going to go into the workforce and what their future plans was. We had some donations that were given to them, some gift cards, some books. And just really just provided them with a large graduation party. Some of the youth would not have a graduation party otherwise. Their foster parents may go with them to the their graduation, they may go out to eat, but they weren't having these really large celebrations. And so we always want to celebrate the children's successes. Another thing that we'll do for kids is, I'm just thinking of two kids in particular. One of them, he really liked to eat snacks. So when he came to court, we came up with those kind of the three things that he was going to do in between court hearings, almost always surrounded around his behavior, sometimes around his grades. And if he met those goals, I would take him downstairs to get a snack, a special snack, in addition to the snacks that we kept in the court. We had another young man who was been in RTCs for years, and we talked about what we can do to get him out the RTC. And he said, well, if I'm good between this hearing and the next hearing, will you take me to lunch? And so, he was able to maintain his behavior, increase his level, and his ad litem and I, we went out to lunch, and that was a celebration of his success for that time, and just giving them something to look forward to. The celebration of success doesn't always come from the bench too. It comes from your staff, my coordinator, to my bailiffs, to my court reporter, the county attorneys that work in the courtroom, the ad litems. We all, remember the things we discussed at the last hearing so we can bring it up at the next hearing, and just talking about something that happened at that time, which for that child that was the only time they were in court, even though we've had hundreds of hearings since the time they were in the last court. It makes them feel that they are important. Like, you remembered that. You remembered that we talked about that. And that's really important for them to know that we care for them as a court, and we care for their successes, and we're really there to make sure that we can get them into the future. I know it was Ms. Morales was talking about this, and it's something that we focus on in our court as well, is you have to remember your staff, especially when you're being trauma focused. That secondary trauma and what we bring upon ourselves can also be very, can be very daunting. It can sit on us. So we do potlucks for lunch, Christmas, Thanksgiving. Sometimes, we'll bring breakfast for everybody, or, have a spread for all the staff. I put this picture up too that has the bailiffs in it. And we know there's a lot going on right now with police officers and, the feelings behind it. And I had a really good bailiff, Deputy Constable, that worked with me for years, that was focused on the children and their well-being as well. He was the one that would take them to get snacks. He was the one that would take them to get their stuffed animals. He did a lot for them. And that also it's an authoritative figure of a police officer, but it's humanizing them as well. And that's also helpful for the children to see that, for the adults to see that other side. So we can really work together as one staff for the benefit of the families and the children.
I think I have controls now. All right, well, good afternoon, everyone. Thank you, Judge Griffith. That was really awesome to see how you set your court up. My name is Judge Rosie Alvarado, and I preside over the 438th Civil District Court in Bexar County, Texas. And it's storming over here, and there's a lot of lightning, so I do apologize if we have any interference for that. I, along with Judge Angelica Jimenez of the 408th District Court, co-preside over the Pearls Restorative Foster Care Court. Pearls Court is a program-based court that focuses on PNC teen female youth aging out of foster care to stop trauma cycles, to prepare them for successful independent living, provide them a village of support, and ensure opportunity for educational advancement, all while using trauma-informed care and TBRI principles. PEARLS stands for preparation, esteem, achievement, resiliency, learning, strength, and stamina. So how did we start? We identified a need on a national basis. 7 in 10 girls in foster care have a baby while still a teen. Only 3 out of 10 graduate from high school. Many end up homeless, and almost all have unstable placement. Just over 6 years ago, in 2015, through the vision of the founding judge, Judge Renee Yanta, Pearls Court began. And based upon these identified needs, the actual real dream that she had, and her mission to heal, love, inspire teen girls in our foster care system, Pearls was launched. Through grants and the Pearls Foundation, we have implemented case management, therapeutic care, and life skills development for our girls. And we are reaching our goals to increase resiliency, provide a support network, and improve self-esteem and increase the success rate of our youth in care. I'm also pleased to announce that our male counterpart to this program launched in 2020, and that is called Eagles Court, and that is presided over by Judge David Canales. There we go. Okay, so let me give you an overview of the court, all right? We have the court and the court hearings, and then the court oversees the programming. The best way that I can describe it is you have the Girl Scouts combined with Big Brothers and Sisters meets the court system, utilizing a three-pronged approach: therapy, mentorship, and life skills training. So let's go back. I keep hitting the button here. There we go. Sorry about that. Okay, so similar to how Judge Griffith does it with the permanency hearings, we try to make it a welcoming environment, oftentimes stepping down from the bench and creating more round table type hearings, allowing our youth to have a voice at the table. And typically we allow them to have the final say after all the adults have stopped speaking. Usually in those hearings is where we identify many of the essential needs of the child and are able to address them there. Now, then we have the program overlay, and we have therapists. We have 2 on staff that provide a litany of therapeutic services. We do group counseling during our program nights, and I'll detail that more in a moment. We have individual counseling where our therapists actually get to deploy out to our youth's location to provide individual therapy. And that's typically in addition to any therapy that's being provided by the department. We have crisis mediation therapy that we provide, placement mediation therapy, as well as family therapy. Then the next component that we have to our program is the mentorship. And these are volunteers that commit to a 1-year commitment. It is quite a bit of time. There is a lot of intense training for our mentors, and they spend a lot of one-on-one time with our youth in addition to spending time and fellowship time with our youth during our program nights. The next component of our programming is the life skills training, and this is really where the bulk of our programming is. We bring in guest speakers from various backgrounds. We end up doing community activities. We have service projects. We have college days. And then we also have a capstone project that the girls work on throughout the year. And during these program nights, we typically address trauma, mental health issues, domestic violence prevention, teen pregnancy prevention, substance abuse prevention, and resiliency and self-esteem building. And during the pandemic, we've actually been able to continue this all on Zoom. One of the cool features is that we do have programming nights twice a month. And in addition to that, we have quarterly days of opportunity and quarterly days of service. Typically on our days of opportunity, we'll go out to a university and we'll tour. We will have a career festival. Our next one is coming up in just a few weeks. It's a virtual career festival that we're hosting for our youth. We have offered them opportunities to go out and learn life skills, such as learning how to fill out an apartment application or conduct a job interview. We also teach them things like how to change a tire, how to compile a healthy grocery list, checking their oil levels. We've taken them out to a litany of places in our community with our community partners to help build those life skills. Additionally, we've done service projects. We've worked with the Blue House. We have worked with rebuilding homes and installing floors for people in need. And that's part about teaching our girls how to give back. So it's a very intense program. Our mentors are there along the way and our volunteers. And then we have our therapists overlay with that. Okay, let's go to the next slide. There we go. Okay. All right, this program succeeds because of community support. Pearls Court is blessed to have deep and consistent relationships throughout the Bexar County community. Dedicated mentors and volunteers are the foundation of this program, and essentially this program functions because of the manpower that they put into it. We have had over 72 volunteers who have dedicated several hours and weekends of their time to serve our girls. Since the inception, Pearls Court has served over 95 female teens in foster care in the Bexar County area. I see our slide numbers wrong, it is 95. And the length of time spent with the court ranges from 1 year to 4 years, depending on the age that our girls have entered into the program. This year alone, we are currently serving 29 female teens, and 12 of them are utilizing aftercare services, 8 of which are attending college. Additionally, as indicated, we have our days of opportunity, and we promote within our youth to give back to our community, and we have accomplished over 244 hours of youth service hours in our community. So let's talk outcomes. Okay, our outcomes speak to the success of the court as compared to the national average. Sorry, the slide keeps flipping. There we go. Last year, during the 2019-2020 program year, 88% of our youth were promoted to the next grade level, and 86 graduated and began higher education, 86%. 92% chose to postpone motherhood, and 90% showed improved stress management and coping skills. Now, while our program is still young and we have not had enough graduating classes yet to get to college level graduation, I'm happy to report that 92% of our girls who entered college have successfully completed their first year. We have found that this specialty court to be vital in the successful outcomes of these teams, and hope to continue and increase our ability to serve young ladies in the Bexar County as they age out of foster care. The program also succeeds because we have worked hard to secure necessary funds to make it work. So at this time, we have been using the Victims of Crime Act Formula Grant Program. It's called the VOCA grant. We are on our 5th year with the program. Additionally, and that program covers our personnel, some of our contract personnel, such as our therapists and professional services. It covers our supplies and our direct operating expenses. Additionally, we have grant funding through AmeriCorps, One Star Foundation, and that covers a staff position as well. And then we have our Pearls Foundation. And Pearls Foundation was a foundation that was specially created for our court. It covers the programming supplies, our dinner expenses, because we do host dinners during our program nights, any mentor and volunteer training that we need to provide, and which we do, days of service and opportunity expenses, and of course, emergency funds for our girls, in addition to our end of year celebration that we do for our girls. Okay, so this is our team. And we have our 2 therapists, our 2 judges, and then of course our staff. Kimberly Morrison is our program manager. And if you have any questions concerning our program operations, she is the lady to reach out to. We are currently working on building a set of handbooks, both a court operations for the program, as well as programming ideas. So that way, when you get this handbook, you'll have a full year of program ideas to implement for your older youth if you intend to open up a court similar to ours. It is still in drafting. We're hoping by the end of the summer that we will have a completed set that we'll be willing to share with any other court and any other jurisdiction. And so if you are very much interested in receiving that information from us, please feel free to get on our list. You can email us at pearls1@bear.org. That's pearls and then the number 1@bear.org. Lastly, if you're interested in finding out more about our program, in our PowerPoint slides, we've listed several links with videos that you can look at to see how our days of opportunity and our programming nights function, as well as find out more information about our court. Thank you.
you'd figure after a year of using this, figure out how to turn off the mute function here. Good afternoon, everybody, and thank you, Judge Alvarado. That was a wonderful presentation on the Pearls Court. As you can see on the slide here, my name is Carlos Phelan Jr., and I'm the Associate Judge for the Child Protection Court of the Rio Grande Valley West. I'm one of a number of associate judges that work with the child protection courts. And I don't see the slide controls. There we go. Here's a slide control. So I'm going to go ahead and take you to my first slide, which is right here. And so what I'm going to do is kind of walk you through my journey in establishing what I call a collaborative court or problem-solving court in a trauma-informed court. And so I'm going to take you all the way back to when I started, which was June 4th, 2012. I was very fortunate in that my first day was actually, excuse me, at the Judicial Child Welfare Conference that was being held in San Antonio. And so I got to jump into some training from day one. And I got to figure out, or I got to ask the question, what am I getting into? And what is this trauma all about? And there was a lot of discussion about trauma at the conference. And I can tell you just my experience was almost like drinking from a fire hose. It was a lot of information, overwhelming. But I could tell that was the approach that was necessary. And that's where we were going to go with our court. And so, you know, it was a new day for us. On the dawn of a new day, it's a new beginning, it's a fresh start, it's a promising turn point. But sometimes it's not all sunshine. Sometimes, you know, you've got to deal with what's left over. And so that's what I did. And so reassessing the practices of the court, our courtroom itself, and the environment that we had established or that had been established at that point was crucial. And so, so we assessed the damage. We looked at what the good was. Time certain docketing is something that we have. We had children in court, which is a best practice. And then we had the bad, of course. We were known for all the wrong reasons. Usually with the county, that was because of our attorney's fees. We had a very toxic environment, extremely adversarial, not a problem-solving approach. We had security issues, and the location just wasn't exactly the best. And so we figured out what the changes that we were going to need to do, and where we were going to go. One of the things that I do want to touch on is the environment. When I got there, everything was an argument. Everything was very adversarial. And getting the group to work together was certainly a challenge. One of our speakers yesterday, Ms. Johnson, talked about the sense that coming to that environment, parents felt like they were out to get them. Somebody was out to get them, that it was not a level playing field, that it was unfair. And so that's one of the first things that I wanted to address, was to make sure that everybody who comes into the court feels like they're being treated fairly and respectfully, and that there's a sense of compassion when we deal with our parties. I wanted to change the atmosphere, and in the sense, parents feel and have felt that the department is always out there to get you, that we got you. And so we don't want that "we got you" approach. We don't want them. We don't want them to feel any more pressure. We want to ensure a healing environment for our parents. And so instead of the "we got you" approach, we want to ensure a "we've got you" approach, so that we can try and help these families. And so started a new job, had a lot of work to do. And the first thing I started to do was look for resources. And so I was very fortunate, again, the first day to go to the Child Welfare Conference, and I got to meet folks from the Texas Children's Commission. I got to meet some of my colleagues, including Judge Hoffman, who was very helpful in helping us get going. And I look for other resources, you know, and that's a typo, but it's the National Council of Juvenile and Family Court Judges. I reached out to them. We became an implementation sites project and committed to change in our court so that we work with our families in a trauma-informed care and that we implement the best practices under the resource guidelines. I realized that there were resources available to with colleges and universities. We have a university that's less than a quarter of a mile away from us. And so we reached out to them and got them involved in what we were doing with the court. And of course, there's materials available through TCJ, who is graciously hosting our event today, and the State Bar. And there's a number of other resources that are available out there. We just look for your colleagues. Judge Byrne was instrumental. We reached out to her and we studied how things were going in Travis County and how we can adopt some of those programs. And so where does it start? It starts with a judge. It really does. I noticed that everybody was working in silos. Nobody was working together. And I wanted to bring them together. And so judicial leadership is crucial. You must be dedicated to change, and you're going to get pushback. People are not going to like it. People don't like change. They are happy to stay in their comfort zones. At the same time, you can't force this. You can't do this alone. You've got to get buy-in from your stakeholders. You got to bring them together. And so I do want to touch on one thing, and that's you can't do this alone. You may want to change the environment, but unless you get that buy-in from your stakeholders, you're going to spin your wheels. You're even going to burn yourself out. And so one of the things that I would recommend is to start meeting with folks. A lot of judges don't like to have meetings, even though we have hearings every day, which are meetings. And start meeting with some of the stakeholders individually, bring them together, have them start talking. One of the first things that we did, we brought our DAs together to talk about the cases. We brought together CASA. That was one of the first meetings that we had. We also brought in the AG's office for the purpose of talking about DNA testing and bringing in our caseworkers who were always questioning DNA. And so that was a good way to bring them to the table and eventually expand from there. The next list in the materials, or the next slide in the materials that I have is kind of the process that we went through. This is not a roadmap for you, but it's certainly not, they're not bragging points. What I want to emphasize is this is going to take a while. You can't do this all at once. And that was a mistake that I made in the very beginning, was thinking that we could change everything in a year. As you will see, this went on for quite some time. And I think I actually skipped over a slide. No. Bear with me here. Okay, so actually I didn't skip a slide. I got the wrong date in there. So August 1st of 2020, I'm sorry, 2012, we actually met with these folks, as we talked about today, and establishing connections and trying to meet together. You know, kind of things that we needed. We established a need for a permanent bailiff. We got that in our court. Very fortunate to have the bailiff that we have, because he's been trained in how to deal with children and families. And so we have a very competent bailiff in our courtroom. We switched over to unit-based docketing so that we don't have 3 different units in my court every day. We can go by 1 unit and they don't have to sit in court all day long. I attended CANI, something I did on my own. So that's the Child Abuse and Neglect Institute by NCJ, FCJ. And some of the other things, got on the commission, learned a whole lot from the commission. We were selected as an implementation sites with the NCJ, FCJ. And that kind of started the process for what we were doing, because with NCJ, FCJ, we selected a court team, just like the team that you brought today. And we expanded the team. I learned very quickly that you couldn't just build a system like this with the folks that you have in court. It requires outside partners to be at that table. And so reached out to UTRGV with Dr. Cynthia Jones, and that made a world of difference in how we were able to move forward. That led to the creation of our coalition called the Coalition for Empowering Children and Families, in partnership with Dr. Jones and UTRGV and the Office of Victim Advocacy and Violence Prevention. NCJ did a courtroom trauma assessment for us. They actually sent over our site manager, and we have a site manager for our court who consults with us and gives us ideas about how we can improve trauma-informed practices. And they use the term trauma assessment, but what they do is they come down and they assess your hearings to see how you're doing them, and they check out the environment and make sure that it's a child-friendly environment, and that we're not increasing the trauma that these parents these families are experiencing. That led to further trauma training, TBRI overview. We got through the help of Dr. Jones and the university. They reached out to TCU, and we had the folks from TCU come down and give us some introductions to TBRI, which led to an empowered simulcast on the Empowered to Connect simulcast, which was also another TBRI training that I made mandatory for our attorneys to attend in order to stay on the wheel. The following year, we did that for our foster parents and our relatives. And it continued from there. You kind of get the idea. It builds as you bring people to the table, but you got to bring those people to the table. And so what does it look like? We're known for our bookshelf project. One of the things that we wanted to do was to create a more welcoming atmosphere for our kids, not just going to court and taking care of their hearings and leaving. We wanted them to take something away with them. And one of the things that we did, and the idea that we had an empty bookshelf, and we started a campaign to bring books to court. And so we loaded those shelves full of books, and those kids are welcome to take one and keep it. And every time they come to court, you can take one and keep it. And you would be surprised at the change in the demeanor of the children. You would be surprised at the engagement of the children with their parents when they have that book. And it made a world of difference. Other examples, snacks. And you've seen that in the other presentations. Snacks are very important. Our attorneys were able to get together and provide snacks for our kiddos. And so there's a little snack box that's there in the courtroom. And when they come in, they're welcome to get whatever they need. You can see that desk there that has some things on it. And that's my bailiff's desk. He's a former Marine. He has a lot of his material up there. And you would think, wow, that's pretty traumatic. But actually, the kids have a lot of questions about the military. And specifically, strangely enough, that helmet that you see there is a Boba Fett helmet. We get more questions about that helmet than you can imagine. And if anybody follows Star Wars, he was a Mandalorian, and there's a huge TV show about that. And so we get a lot of, that's a conversation piece that we have with our court. And so our lobby, another example, white walls, very sterile. We were able to work with Dr. Jones and get a grant through the Texas Bar Foundation to paint those walls. And the transformation was tremendous. The artist Eddie Martinez convinced me to paint the walls black first, which I was really scared of, but it turned out to be a great improvement to our court. You can see some examples of the work there that he had done for us. And we're looking forward to getting back to our courtroom as soon as we can. The office, one of the first things that I focused on is meeting with these children. I didn't want them to just go to some office. I wanted to go to an office that was more child friendly. You can see art there from the kids on the wall. You can see what judge's office is going to have minions on the wall. And so we have a lot of things there that we try to make it as welcoming as we can for our smaller kids, as well as our older children and our teenagers. Partnering with the university is key. A lot of folks, you know, they're there. Universities want to work with our population. There's a lot of studies that they can do. There's a lot of things that they can learn from us, and they're willing to do so if you reach out and establish that partnership. We did, and as a result of that partnership, the university opened up to us. We can now have kids attend athletic events and music events, well, at least pre-COVID anyways. And so that was a very fruitful partnership with the university. It remains one, and one that we continue to develop. It also led to organization. And what I mean by that is that when you get everybody together, everybody starts talking and everybody wants to work together. And we actually, one of the fruits is we had our bar association. We now have a subsection of the bar for child welfare specifically. And so our attorneys were able to organize and do drives. As you can see here, this was a coat drive a couple of years ago. And so we really reaped the benefits of changing the environment and being able to work with one another. And this last slide, this is not how it's done. This is a remnant of what was before. And it's a plaque that we have in the very back of our courtroom, our court area, not in a courtroom. But that's not trauma informed. Court is not about cracking skulls. Our court is not about cracking skulls. It's about healing. It's about helping these people overcome their issues and helping children get back home to their parents. And so there's my contact information. If any of you have questions, I will point out that all of us were very rushed through this. We could go on for hours about what we've done in our courts, and you're more than welcome to reach out to each one of us if you have any questions. And I appreciate your time. Thank you. And so we're going to have our judges come back on. And let's see. There's Judge Clark. All right, so we're all back on. And as I stated before, 12 minutes just barely scratches the surfaces of the work we're doing with our courts. And so we're going to delve into this a little further with some questions for our judges. And so I'm going to go ahead and begin with a question for Judge Clark and Judge Alvarado. You mentioned in your presentation about training court teams. Can you expand on how you approach this training, who was included, and what type of training was offered? And we'll start with Judge Clark.
Well, my computer just kind of blipped out. Could you, I've got our guest reloaded. Could you go on to Judge Alvarado and follow up with me, please?
I'll be
Absolutely.
happy to, Judge Clark. Thank you. So we have 2 levels of training that we provide. Our level 1 training deals with our staff, and then our level 2 training concerns all of our volunteers and mentors. Our staff are trained in dialectical behavioral therapy, DBT, and trust-based relational intervention therapy, TBRI. This training was provided to our therapists and our court monitor through grant funding opportunities. I have also received training through the Karen Purvis Institute of Child Development at TCU in TBRI. I have a certificate in TBRI now. And then with respect to our volunteers and mentors, all of them go through training. They are trained by our staff in the areas of policy, expectations, safety, understanding the CPS system, TBRI, and the utilization of DBT. We do training sessions, and I'll explain that in just a second. And then our mentors then turn around and implement the DBT strategies and principles on one-on-one with our youth. So pre-COVID, we were doing these trainings in person in 2 full-day Saturday sessions, and then periodically during programming while our youth were attending their group therapy. And then post-COVID, we did the training through Zoom and compiled, or I should say during COVID, we did it through Zoom and compiled a series of videos and handouts for our volunteers to complete. And then we also, again, during Zoom group therapy session, when the girls were at group therapy, we would do the training with our mentors as to those specific areas that we were working with the girls on that specific day. So that's how we do it.
And I'm sorry, my computer seems to not be wanting to work at all now. So the training, we did trainings similar to Judge Alvarado. We had brown bags at lunch where I would invite speakers to come in and talk about things. At that time, TCU was having judicial summits. I got grants to take folks up there. I got a grant from the United Way. I was able to use training funds from my drug court. We went to national conferences as well, getting grants. So you just have to kind of be creative. I sent folks to TCU to get certified as Judge Alvarado is. Then they can teach others as well. So, there's various ways to do the training, but of course, money is always an issue. So, but everybody on the team needs some general training so they can speak the same language.
Absolutely. And so as a follow-up question to that is, what was the effect and importance of the training aspect?
Well, for us, it's vital that all levels of the program utilize the same language and approach when assisting our youth that have been in trauma. So making sure that everybody is trained on the DBT and the trauma-informed care at all levels, judges, case managers, therapists, and volunteers. That ensures that everybody is on the same page and that our youth are getting a very holistic approach to trauma-informed care.
Exactly, I couldn't agree more. Even the clients, if you've watched the documentary, even the clients start talking the language. And they're able to identify with their trauma and what happened, and talk about the brain and all of those kinds of things. So it's critical that the attorneys be able to, it changes their mindset as well. I mean, we're all there in an adversarial system. When we have to be adversarial, we are, of course. But the training, everybody on the team needs to understand what's going on.
Very good. This is a question for all judges, and we're actually going to start with Judge Griffith on this one. Describe some intentional process changes. Describe some intentional process changes that you made that were cost-free or low cost and relatively easy to do.
So the first is just having a conversation with your staff, at the very beginning on how we were going to handle things, as far as making sure kids coming in felt comfortable. My court coordinator will greet the kids when they come into the courtroom, or they'll be greeted by the bailiff, or they'll be greeted by our court liaison, just increasing that comfort thing. That's something you guys, when we start getting back into the courtroom, that you can just start right away. Is like, how can we make people feel more comfortable coming into the courtroom? Another thing we can do, the low cost, is the little things like snacks or getting books donated, stuffed animals. Every kid that leaves the courtroom, we offer them a stuffed animal that they're able to go choose which one they want to. Most of those things come in through donations, the snacks and stuff. A lot of times that's done by my staff. You can also, if you go to the store and you see like some kid-friendly art decoration, you could pick it up and bring it back to the office or wherever you have the kids stay. Just anything to kind of increase that comfort level. A lot of that stuff is very low cost, and a lot of that was donated. When people see you start doing that as a judge, they jump in as well. It's like, oh, can I help with that? Can I bring that? I know somebody that donates stuffed animals. I know somebody that does this, or can do a balloon bouquet, or you get a lot of that coming in to help with that process.
One of the things that I would recommend, which is what I put in my presentation, is go to my packet. Liz Watkins did a great job of doing a list of things that were low cost or no cost. And then of course the biggie that it really guides how you do your processes, and what you're doing is to implement the phase plans. I can tell you it'll take about a year to convert your court, but if you start on Monday with the new cases, within a year, just about, you'll have them all converted, and it keeps everybody on the track, and it keeps the clients from getting lost from what they're supposed to do.
For me, part of it is just humanizing the experience for them. Slow down. Oftentimes we see in these PMC hearings, they're scheduled back to back to back to back to back, and it's just like one after the other after the other. So part of our program and part of the way that we have our structured is that we've slowed it down. I usually allot 30 minutes of time for each one of our kids. And so it gives them more opportunity to listen, digest what's happening in their cases, and then gives them that opportunity and platform to speak. Additionally, instead of scheduling, and this is quite a bit of work on our part, but instead of scheduling the hearings out every 6 months by statute, we every 3 months, and sometimes in crisis situations, I'll do every 1 month until that child is out of the crisis, to continue to aid and make sure that all the needs are being met. Another way I think that's just really low cost is creating awareness, talking to your DAs and your ad litems that are before you and recommending that they also read trauma books. There's some books out there that I recommend, which is What Happened to You, Conversations on Trauma, Resiliency, and Healing. And then The Boy Who Was Raised as a Dog by Dr. Bruce Perry. That one's on audiobook as well. And that one really had some very insightful information as well. So I think understanding client perspective creates patience, empathy, and compassion, and that doesn't cost anything.
Absolutely. I mean, I can't emphasize the fact that, you know, when you have donations, when you have people donating their time or things for the court, it can certainly bring people together. For the example, the book project that we had, that was taken on by the attorneys, and they did a social media campaign, and we had folks donating from all sorts of areas, not just child welfare. We had teachers coming in. We had students in schools starting drives of their own and bringing books in. And so if you're looking for a way to bring people together, that is something that you definitely can do. And that's just an example from my court. Let's see, Judge Griffith. Another element of trauma-informed courtrooms is the physical environment. Before the pandemic, what physical changes were important to your courtroom approach?
The physical change we did, which I showed in the presentation, was the transforming of the jury room. We did that, as well as just making the courtroom a lot more friendly, bringing out the stuffed animals. Something real simple, I brought in little step stools to put in front of the bench. Why? Because a lot of kids can't see above the bench. So we put a step stool in, they hop on them, and then they can see me, I can see them, or I'll stand up and reach them if, you know, some are still a little bit too small, but just little things like that make the courtroom, for me, because I'm dealing with PMC, mainly dealing with children, a lot more friendly for the kids and make it a friendly environment for them.
Of course, we would all be remiss if we didn't acknowledge the fact that our courtrooms look very different now. Even some of us holding in-person hearings, it's different. How has your court adjusted to virtual hearings and social distance measures? I guess we'll start with that question, and we'll go to Judge Alvarado.
Okay. All right. So Pearls and Eagles court programming and hearings have pretty much moved completely online since for the 2020-2021 program year. With the need for the protection from COVID, we knew maintaining relationships with the youth was going to be probably the most vital, as opposed to just implementing the skills program that we usually do in the programming. So we're still meeting twice a month, but we're just doing it online. We've streamlined our effort and removed the extras that may have filled in-person time through being conscious of how much screen time everybody is having these days. And so usually our programming nights were like 2 hours, sometimes 2.5 hours long. Now we've reduced that down to 1 hour and become very focused and concise in what we're trying to do during that time. And that is, of course, therapy and relationship building, connectedness, taking priority over the life skills training. We do set up breakout sessions to utilize privacy when there's a youth that's in need to either need to speak to the mentor or one of our therapists. We remind our girls of the privacy nature, and so to be very conscientious about those that are around them in the Zoom world. So we try to ensure that while that they are participating in our programming nights, that they are in a location that is more private. And then, of course, we are still having socially distanced events that we've set up. We've done drive-in movies. We have done art nights at home where we have deployed art projects with little baskets of all kinds of stuff that they can do. And then we all Zoom in and we have a painting night. We have our online career festival that we're doing. And also with our therapists and our mentors, they have been deployed out again in socially distant and safe measures have been put in place to still have those relationship building with our youth.
Okay. Judge Griffith, same question. How things changed for you with virtual hearings?
Well, a lot of the things that we did in the courtroom, you know, obviously we can't do. And I see the effects on some kids too, because I have some kids mention, I don't want to come back to court till I can get my stuffed animal. So, you know, at the beginning, we had a lot of kids participating. And then, you know, as we hit the year mark, some of the kids are starting to phase out on their participation. It's changed the style of the hearings a little bit. We like to do the round table, but I did find with on parents' cases, it's become a lot harder to do more of the free-flowing hearing, just all the talking over each other. So when we do have parent cases, we've gone back to the standard question and answers, unfortunately. just to make the hearings, make sure we get all the information and get it smoother. We have had to stop our PAL dockets, just kind of the style that we've done that, but we're definitely looking forward to getting those start back up this summer. But it's been a difficult adjustment, but we still try to encourage the kids to come. We do a lot of contact now with the kids in the breakout room, so they're not staring at 7 people on a screen. It's just myself and the attorney ad litem to keep the kids engaged and keep them conversating with us.
Thank you. Do you have any? We're going to take questions here shortly, but with time. But I'm going to go to each one of the judges and just ask you, do you have any final advice for our audience on how court teams can start implementing trauma-informed practices in their court? And I'll start with Judge Clark.
Well, the way I started, when I had a conversation with Dr. Purvis at a training that I was at, that's where I met her, and I had her come and talk to our group for the brown bag, and that was caseworkers, CASA, lawyers, and that was a good way to start because it kind of gave us information on what trauma was, how it was physically and mentally affecting the kids and families. So something that was kind of motivational is what I did to start, because you've got to kind of get some buy-in from your group. You are exactly correct. The judge can stand up there and lead all day long, but if the general doesn't have an army, he's not going to go very far. So to get there, and you can use something. I had a judge in Mississippi, and he used our training as kind of his kickoff to get everybody there and get on the same page. Just some event or idea that would get people really questioning what they're doing.
Judge Alvarado?
I think kind of twofold. I think one is, first and foremost, talk to your court team and identify the need in your area, and also what the specific goal is that you're wanting to accomplish. Are you wanting to focus on a specific youth area like we do with respect to our older girls and our older population? Or I guess the question is going to be what it is that the goal is going to be first, and identifying that. That from there, then, I would suggest talking to your youth, asking your youth specifically what it is that we can do to help you and how can we be of service to you. They're a great source for providing information. From the beginning with our program, our youth have led the development of the program by letting us know what they want and what they need in the program. They get to pick their capstone projects. They get to pick what the theme is going to be for the year. They have a lot of say in how the program develops throughout the year. And so I think one is first working with your court team, and then identifying through your youth how to develop the program based off of their needs and wants.
Judge Griffith.
I would agree with Judge Alvarado. I think it starts with the conversation with your core team, about what you want to do in your court and how you want to focus becoming a trauma-informed court, and going from there.
Definitely agree that the court team is crucial. Building that court team, which you've brought today, and hopefully that's the seed for growing your trauma-informed court, and your group will grow, and you'll bring others to the table, and that'll bring other opportunities. And of course, everybody's worried about funding, but you'd be surprised by bringing those folks to the table and what they can bring with them. And so I'm going to go to Miss Kathy, and I think we got some questions, correct?
We do. Thank you, judges, so much. I think we have all learned so very much from all of you. We have a number of questions. I think we may only have time for one. The commission will follow up and work with the speakers to answer the other questions, but this question could really go to all of you. It came during Judge Alvarado's presentation. It says, having the children present during the hearing seems that it could be loaded and complex. My initial thought is that would have to add to the traumas of the children, as well as to the parent. Has that been your experience or not? So perhaps several of you, all of you, Judge Alvarado, it came during after your presentation.
I think it's kind of a case-by-case situation. As we get through these hearings, we get to know our children, and we know which ones are going to be needing maybe additional and special parameters to operate the hearings in. I would say probably about 90% of the time, the hearings run very smoothly. The girls are incredibly engaged and very vocal and speak out. And I think part of that is because of the programming component, that they have become very comfortable with the court staff and me as their judge. And they've learned and developed a rapport and trust with me. And so in doing such, our hearings run very smoothly. We have had the occasion, however, where some of our youth have been very sensitive to the hearings. Either they were dealing with a crisis during that time, or they just chose not to come. Sometimes they've in advance requested not to be in attendance. And those are things that we take into consideration. A lot of times with respect to those type of situations that arise, that's where I really depend on my court staff, my program manager, my court monitor, to be communicating to me in advance of these hearings, these special developments that are taking place. And then we make a decision at that point in time. And then sometimes just the youth themselves will make the decision that they're just not going to appear that day. And that's fine. But for most, I would say the great majority of the time, it is a very positive experience because of the programming efforts that we've made to develop the rapport and trust with our girls.
Would anybody else like to respond quickly? Or
I think that you heard this morning how important it is for youth voice to be present in the courtroom. They wonder what's going to happen with their case. And of course, on a case-by-case basis, you want to be careful with some of our kiddos and that there's some things that they should not hear, or that if it makes them uncomfortable, they shouldn't be there. But for the most part, I think that foster youth and former foster youth have said all along that they have been excluded from the court proceedings. And we're certainly, at least in my court, not doing that.
okay. I just want to thank each and every one of you so very, very much. I know we have learned so much, and remind all of the attendees to please complete your evaluations for this presentation. And we will take a brief break and be back for our next session. Thank you again so very, very much.
Thank you.
Thank you.